Good evening and welcome to First Day Chats by Dr. G. I'm Dr. Adana Grandison, a physician in Barbados and your hostess for this evening. First Day Chats by Dr. G is a live podcast that provides listeners with a unique opportunity to not only hear complicated conditions explained, but also clarify any misunderstandings you may have about that condition. After all, a medically aware and educated patient is an empowered patient. And this evening, our episode is entitled Medicine and Law. And our guest is Miss Marilyn Moore. Miss Moore was born in England to Barbadian parents and always promised that one day she would return to work and live in Barbados. She has practiced as a solicitor in England for 8 years, mainly specializing in personal injury claims before undertaking the conversion course at Hugh Wooden Law School in Trinidad in 2003 to be able to practice in the Caribbean. She was called to the bar in Barbados as an attorney-at-law in 2004. When she relocated to Barbados in 2004, she first worked in a practice specializing in civil litigation before stepping up on her and actually establishing her own practice, More Daisley, in 2015 with her partner, Lanny Daisley. She is in clinical practice and she likes clinical practice a lot. And she has their practice More Daisley actually has an emphasis on civil litigation, which includes personal injury, clinical negligence, judicial reviews, debt, and employment. More Daisley also specializes in estate matters, conveyances, mortgages, and company and commercial matters. Good evening, Miss Moore. And I'm just going to wait for Miss Moore to join us now as she calls in.
Good evening.
Hello, good evening, Miss Moore. How are you doing?
I'm well, thank you.
Good evening. So I wanted to start by saying thank you so much for joining us this evening. This is a little bit on the periphery of medicine, but nonetheless a very important part of medicine. I wanted to start this evening by first asking what really is tort law?
The simple definition of tort is a wrong in civil rather than criminal law. It
Right.
usually requires a payment of money, known as damages, to make up for any damage that has occurred. It's distinct from criminal law and contract law. To take it a stage further, negligence is the most common type of tort,
Right.
and negligence can be defined as the failure to take proper care in doing something. So in other words, it's the conduct that falls below the standard of behaviour established by law for the protection of others against a
Okay.
unreasonable risk of harm.
So, so
To go a stage further,
go, okay, go
sorry,
ahead. Go ahead. Go ahead. Go ahead.
I say clinical or medical negligence is a type of negligence. So essentially that's the tort. So clinical negligence or medical negligence is a type of tort.
Okay. Okay. So you stated just now that really clinical negligence or tort to begin with really is you performing a duty at a certain standard. Is
That's
that correct?
correct.
Based upon right.
Yes, that's
And
right.
any time that you don't provide that standard of care and it falls below that standard, you can be considered negligent. Is it as simple as that, or is there more to it?
There is a lot more to it, but that is,
Good.
in very simple terms, that is it. So
Right.
what I would like to do is take you through initially
Good.
what is medical negligence. Medical negligence refers to medical professionals, so doctors, pharmacists, anybody who really provides medical services. It's an act of carelessness which causes harm to a patient. So, for example, and this is a very obvious example, if you had an injury, say to your left leg, and you went to the hospital and it was determined that you needed an amputation, but they actually amputated your right leg rather than the left leg, well, that would have been the level of carelessness on the part of the doctor for amputating the wrong leg, and
Right.
therefore you would have a potential negligence claim against that doctor. That's in very
Right.
simple terminology.
Okay.
So the question you have is, what do you need to prove to succeed in a medical negligence claim? There are 4 elements to it. There's a duty of care, and then there's a breach of that duty, then resulting injury was suffered, and a result of that injury, and that injury was suffered as a result of that breach.
Right.
So it seems relatively straightforward, but all 4 elements have to be proven for you to succeed on a claim for medical negligence. So
Okay. So again, you said you need to establish that there was a breach in that there was a standard of care that was not followed.
that's right.
That standard of care resulted in injury. The injury that it resulted in can be directly tied to that breach as a result of not following a particular standard of care.
That
Am I
is
correct?
correct.
Okay, good. So we're on the same terms. So we're
That's
learning
right.
together a little bit of law, although we're on the medicine side this evening.
Sure.
Yes, good. So is it always as straightforward to make that claim? Because sometimes we may we may have a situation where, for instance, because you gave a very clear case, but are there any other cases that can sometimes be a little, in the gray area? For instance, let's say you have some person that may be operating as a provider of healthcare, whether
Mm-hmm.
it's a doctor, a pharmacist, anything of the sort, and it, they are practicing outside of their scope. Is it that they would be judged based upon what would be acceptable by their peers within that space? Or is it that they would be judged based upon what would be acceptable for a specialist?
No, it's based upon the what is accepted for their peers in that field, essentially. So, in terms of the standard of care, what it is, doctor owes a duty to exercise reasonable skill and care in his
Right.
treatment of a patient. That is the definition. So, it's what is then determined as reasonable skill and care. So, he
Oh,
isn't obliged to achieve a success in every case that he treats, but
right.
he must be able to show that in treating that patient, he did exercise reasonable care. So, for instance, if you hold yourself out as a plastic surgeon, just as an example, and you're a general GP, you have to come up to the standards of a plastic surgeon, not a family physician, in terms of dealing with that.
Right. Okay, good. So you just brought out a very key point, which is because a negative outcome may come as a result of that care that was given, it does not always connote to being negligent. Explain that a bit for us.
Yeah, because like I said, you can have a situation where there is negligence. Let me give you an example. Okay, say for instance, somebody has leukemia, as an example, which might potentially shorten their life expectancy. So, as a
Mhm.
result of the leukemia, they might have died a few years earlier than the standard time.
All
Now,
right.
they went to the doctor, and the doctor prescribed the medication, and it was the wrong medication. So that person will die earlier as a result. Was it as a result of the leukemia, or was it as a result of the doctor's negligence? And that's where
Right.
we get into the realms of when you're proving the standard of care, you also have to look at causation. Would
Mm-hmm.
this, whatever the event was that occurred, would it have occurred but for the negligence of the doctor? So it's like
Right.
a two-prong test.
Okay. We have some questions actually coming in quite quickly this evening.
Okay.
Our first question really is from Ellie W7003. She says, "Good evening. Causality can be difficult to establish if more than one medical professional is involved. How can you define where the breach that led to the injury occurred if if multiple doctors are involved? For example, GP offices, emergency rooms, surgeons, etc.
You kind of have to go backwards and do like
Okay.
an exercise where you look at what would have happened and what should have happened and who had what duty to do whatever it was they were supposed to be doing. So
Right.
oftentimes in a negligence case, you often could be saying it was the nurse's fault. For instance, this is say a hospital situation. The doctor would say that he told the nurses to do A, B, or C. The nurses
Okay.
didn't do it. As a result of the nurses not doing it, something else occurred. The doctor would then
Right.
say, but if the nurses had done what they should have done, it wouldn't have happened. But then the doctor should have been ensuring that his orders were carried out. So you have to do it like stage by stage and work backwards to determine what should have happened in the circumstances.
So in a situation like that, you want to encourage also something like closed loop communication, that when the instruction is given, that also you get back information about what has actually transpired, and if that order that was given was essentially followed through to try to
And
mitigate the potential for risk.
correct. And just to add to that point, medical notes are of critical importance in
Right.
respect of what we've just said, because the medical notes is the aid memoir to what happened and also shows what instructions were given. So if you
Right.
want to put it another way, you want to push the blame to someone else, you need to have good medical notes that you can see what should have happened, and then when it didn't happen, what went wrong, and a result of whose action did it go wrong.
Okay. Now, I know a lot of persons would probably say, but sometimes doctors don't write always the best, or we can't understand what doctors write. How big a part does that play? And do you have any recommendations, maybe for even the professionals, the medical professionals out there, in terms of their the importance of writing legible notes?
Yes, that is extremely important. Notes only become important, you see, generally speaking, either when someone else is taking over the care or in a legal setting when something has gone wrong. So the
Right.
more legible your notes are, the better it is for you if you are trying to prove your innocence in terms of something going wrong. And oftentimes we find that the notes are illegible.
Hello. I think we have lost you, Marilyn.
Oh, okay, I can still hear you. Let me just see.
Okay, good. I can hear you again now. Go ahead.
Okay.
The notes that are illegible.
Oh, you missed what I said? Okay, I said
Yes.
sometimes the notes are illegible, or in actual fact, there are no notes at all. And when
Right.
that becomes a problem is in a legal setting. Because
Mm-hmm.
obviously, if someone makes a complaint, the doctor will have dealt with a number of patients, depending on what setting it is. And so the only way he or she will remember what has happened is if he refers to the notes. If the
Right.
notes are illegible, all right, he might be able to read them, but if nobody else can, that is a problem. And if he hasn't kept adequate notes or at the time contemporaneous notes, that is a problem too.
Right. So we have here the essential four tenets that you have to make sure to cover: a standard of care, a breach in that standard of care, injury has occurred, and linking that injury to the actual breach in standard of care.
Yes.
Tell us, how long do you have to issue a claim at, or essentially what is the length of time that you can have between issuing a claim at the High Court from the date of the alleged negligence?
You have
What
three
is the
years.
statute of limitation? 3 years.
Statute, yes, that's what
Okay.
I was just going to say. It's a statute of limitations, and you have 3 years from the date of incident in which it's either the date of the incident or the date of knowledge. So there's a
Right.
distinction between those because sometimes, obviously, the date of the incident will be obvious if, like the example I gave, it was an amputation of the leg. But the
Okay.
date of knowledge might be less obvious if it was a case of due to the doctor not taking some particular action, the leg had an issue, an infection, which it then had to be amputated. That would be
Right.
from the date when we realized it had an issue. That might be the
Right.
relevant date. But whichever date, it's 3 years from the date of the incident to issue a claim at the High Court. You don't have to
Okay.
wait to the end of the 3-year period. The sooner you start your investigation, because it takes some time to get the medical notes together, to get the experts that's going to advise on the evidence and so forth. So once you feel that a claim is possible, you should seek advice as early as possible.
Okay. So I wanted to ask you to essentially just walk us through that process. What is it like?
In
From the
terms of
time
what happened,
a client comes to you and say, Miss Moore, I got my leg cut off. It was supposed to be my right leg. I got my left leg cut off, and I am very upset. And I think I want to take action. Walk us
right.
through that
So
process.
the first thing we would tell them is the limitation period. So it's important to establish when this occurred, because you will find that people will come to you 5 years, 10 years after the event, and essentially that is too late. It is not impossible to extend the limitation period, but unless there's good cause, it's difficult to do so. So the first thing we tell them is you want to ensure that you issue the proceedings before the end of the limitation period. Once we've
Right.
established that, then we would take the evidence as to what they said happened, how it happened. Then the first thing that would need to be done is to get the notes, whether that's from the family practitioner, the hospital, if it was a hospital case, the pharmacist or wherever, we would need to get those notes. Once we've got those notes and we've reviewed them, depending on what the complaint was, we would send it to the relevant specialist, someone in the field who would be able to be held out as an expert. So what they would then do is look at those medical notes, look at the facts of what the patient has actually said happened, and determine whether or not there was a likely case. Obviously, that's only that person's opinion, so it then still has to go through the court. Some are obvious, some are less obvious. So using the same amputation example, it's pretty clear cut that once you get the notes and once you can see that the complaint was to the left leg and then the right leg was amputated, or whichever way, look, I can't even remember which way around I said, but
Right.
it was amputated in that particular case, it would be pretty obvious that there should be a case to answer. But
Okay.
in other cases, you possibly need the initial expert's report, and then he will refer you to other specialists because there are many that will be involved. So just as a simple example, have one where there was a person that had a heart attack at a hospital. And in terms of that heart attack, we needed a cardiologist. He also had a stroke. We needed a neurologist. Then we needed a family doctor to say what should have happened. So by the time we finished, I think we had about 4 or 5 doctors or specialists, and that was only in relation to the liability part of the claim, determining
Right.
whose fault it was that he suffered these injuries.
Okay. So the client has come to you because they're not patients. I keep saying patients because I'm so accustomed to having patients of mine. But the client has come to you. You have walked them through the entire process. You have gotten them the additional persons or experts to be able to review that information, and it goes to court. How do you now, as a lawyer, go about actually proving those 4 tenets that need to be established in order for someone to be successful at a claim?
Okay, so what we do, we have to prove the things that I said, and I'll just take you through how we go about proving them. So in terms of a duty of care, it's pretty easy in a doctor-patient setting to establish that there was a duty of care owed. We get into some grey area when we say things like in terms of ethics and law. If it's someone when they call for help on a plane, for instance,
Right.
is there a duty of care owed by that doctor? Because he's obviously not a patient. It's not the normal doctor-patient situation, but obviously a doctor has a code of ethics in relation to whether or not he can walk past a situation where someone obviously needs medical attention or not. So proving the duty of care is pretty easy. The next point, though, is, as I said before, a doctor owes a duty to exercise reasonable skill and care in his treatment of the patient. and that's a little harder. So he's got to do things like the question, sorry, that you have is how do you assess that standard of care?
Right.
And it's a two-limbed assessment. You have to first establish what is the standard of care, and then you have to say, so what's the customary practice, and whether that doctor has come up to that standard. And you do that through the use of your experts. But
Right.
equally, just as your expert might say, this is the approved standard, the expert from the defendant, which would be the doctor or the hospital or the pharmacist, is likely to say, no, this was the approved standard, and what they did was correct. So you have
Okay.
to competing evidence, and you just have to go through the evidence and point out the flaws within it.
Right. How important is it to have especially in institutions, following on from the question that we had from the message board, in a situation where you may have multiple physicians existing, how important is it for that standard of care to be followed by use of things like guidelines and standard operating procedures?
It's very important because, like I said before, if everything goes along and there's no complaint, there's no problem. But when it goes wrong, it has to stand up to legal scrutiny. And the only
Right.
way that the legal scrutiny can be dealt with is by looking at what the general standard is. So if you deviate from that standard, if you don't follow the guidelines, if you don't keep up to date, all of those are things that suggest you have fallen below a reasonable standard of care.
Right.
And so therefore, in terms of that general and approved practice, you're going to be hard pushed to say that you have followed it.
Right. Right. We have another question here coming from the message board again. If a doctor gives oral instructions or has a telephone conversation with the patient without recording the conversation, how does the doctor prove that they gave instructions if the patient denies it?
That's a difficult one, and I've got one similar to that at the
Right.
moment. The only thing I can say is notes are there for you to document what was said. And then it's
Right.
going to be you have to challenge the credibility of the person saying that they.
Hello, Miss Moore. I think we just lost you again just now. Hello. Not sure. Can everyone hear us?
Did I lose you?
Yes. Hi, Marlene. I think you just dropped out there just now. I think the connection was a bit um, bad at that point. You
Oh,
said
okay.
that it's a bit difficult to prove that because it's really left up to you to document that you have given the instruction and then to question the credibility of the person who denies it. Is that what you were saying?
Yes, exactly that. Because that's all you can do. Obviously, in times moving forward, maybe it's a case where when you do speak to a patient, you record it for your own benefit. But at
Right.
least if you have it if you've documented it clearly with date and time and a brief note of what you've actually said, then at least there's something there that we can challenge the evidence of that patient who is then saying that you did not say X or Y. And
Okay.
whilst not having adequate notes is not necessarily negligence, it does
Right.
show a level of carelessness, which various inferences will be drawn. So the key
Right.
issue is to protect yourself the best way that you can.
Yes, absolutely. Actually, I remember when I was in medical school, I was always told your note should be able to stand on their own without you even representing your notes because you should be so clear in your notes as to what is happening or what instruction you are given. So in the event that your notes ever have to represent you, that is very clear in terms of how you can follow the note. Um,
Definitely.
okay, so we have a follow on from that question. And if the patient still denies the conversation occurred, then what?
Like I said, but at that point, then you would have to tell them that there are rights, they have rights, and then they can make a formal complaint. But once
Right.
your evidence is documented, once you're
Right.
represented, that will go a long way. And then definitely you can challenge the credibility of that patient, because the patient might say you didn't do such and such, but then they might have a prescription, just as an easy example. So
Right.
oftentimes when they say that you didn't do something and it said that it was done, you can challenge that evidence. But there's no hard and fast rule. It's just, I would say, again, protect yourself going forward the best way that you can.
Okay. So you have this new space of, well, it's relatively new within the Caribbean, but certainly not a new space in the international context. But we have this new space of telemedicine, where sometimes you are not physically seeing the patient. You've seen you've interacted with the patient electronically, and something goes wrong. Then what? How would you have established that, for instance, there was a duty of care that was breached?
Telemeds. I haven't dealt with any so far, but that's an interesting one. It's still going to boil down to the same thing. Obviously, I
Right.
don't know if going forward telemed consultations are recorded, and if they're
Right.
not, they probably should be to
Okay.
protect you, because at least with the recording, it can be heard by everybody and then the evidence considered. Again, it will boil down to your notes, your note taking and what was said. And then if it has to be challenged, it will be challenged on evidence if they bring a claim against you at the court.
Right.
But
Okay.
again, probably doctors should actually consider to record all these cases going forward, just to avoid any liability against them for people saying they weren't advised X or they were advised Y.
And that is certainly with the consent of the patient undergoing the
Yes,
consultation. Right,
definitely.
great. Excellent. So we have a situation where we've seen a case like this. I remember there was a case probably back, I want to say in 2018, but no, actually probably earlier than that. Probably back in 2015, where a patient presented this is not in Barbados, a patient presented in a hospital, was actually sitting in the waiting area of that hospital, had a medical event that transpired in that waiting area and resulted in the death of the patient. Okay? Can you walk us through that step in terms of explaining, one, the standard of care, where there was a breach of a standard of care, because no one actually had seen that patient as yet. Some persons may say, well, I didn't even accept to essentially have a standard, to issue a standard of care to the patient. So can you sort of clarify um, how you would approach a situation like that?
Yes, and that will go down to the system that you have. You said it was in a hospital, correct?
Correct.
So it starts with the triage system, because obviously when that patient walked in, somebody should have first assessed.
Hi, Marilyn. We actually lost you again. Hello. Hello.
in determining what should have happened. So potentially that triage system was the first part of the negligence action, that nobody assessed
Marlon,
that. Can you hear
wait,
me?
Marlon, I
Yeah.
just want you to go back to the beginning because I think we lost you initially.
Oh,
So the person presented to the hospital.
yes. And so when you normally present to the hospital, the first thing that happens is you're normally assessed by the nurse or someone in the triage system, or the
Hmm.
triage system, depending on how you pronounce it. And at that stage, they should have determined how ill the patient was, how
Right.
urgent was the care, or how urgent was that patient should have been seen by somebody. It sounds like obviously that stage was initially missed. The person then sat there and had the length of time. There's a question that would be then in terms of the standard kit of care, with the patient presenting with the symptoms that that person had, what would be the normal length of time in which they should have been seen?
Right.
If they had been seen within that normal period of time, would the incident have occurred? And depending on the answer will determine whether or not there was negligence or not. Because in all honesty, and that's what Glenn goes on to causation, which I'll explain a little bit about in a moment, that person might have had that incident whether or not they were seen in that hospital. It might have been something that would have occurred in any event.
Right.
So there will be negligence in the fact they might not have seen them, but whether or not there'll be negligence where they get compensation depends.
Okay, understood. Is there a benefit of having an internal auditing mechanism within an institution to handle matters such as this?
I definitely think so. And a lot of times when things go wrong, the patients don't necessarily want money because obviously it doesn't alter the fact. And the whole aim of damages is to put back in a position money's worth because obviously they can't put you back. If you've lost your leg, they can't give you back your leg. So they would have to give you compensation for you to be able to get a false leg or a prosthesis, essentially. But yes, if that happened, that would definitely help. Accountability through all the various departments to assess times and so forth and what is actually happening. But as
And
I was
certainly to
saying, oftentimes clients come and they don't necessarily want compensation. They want to know what went wrong and how could it be avoided in the future.
right, right. So really, it's to close the loop to ensure that if an error did occur, especially an error that could have been um, prevented, certainly that it does not happen again.
Yeah,
What
exactly.
about what about a situation where an incident started to occur? You had an event, a medical event that occurred, intervention was given, the intervention caused at the very end a positive outcome, but it started off with a negative outcome due to a breach of care. What happens in a situation like that? So let's say the patient came in, they were in the waiting area, they did not have triage, and the patient um, had another seizure. Let's say they came in because they had a seizure to start, and they were waiting in the waiting area, and they were never triaged. And while they were waiting, they had another seizure, and they were then rushed into the care facility and received medical management, which did not cause any further damage, or better yet, they even had a positive outcome. What happens in a situation like that?
In order to succeed for the negligence, you have to prove that you suffered a loss. So,
Right.
suffering the seizure could technically be a loss, but if there was no major detriment in terms of suffering it, and like you said, there was even a more positive outcome, it's likely that that claim would not succeed.
Right. Okay.
Because in addition to you have to show the negligence, you also have to show that that negligence caused a loss. So whilst you had a seizure, if it could be proven that you would have had a seizure in any event, and then the outcome was actually better than that would have been, you haven't been able to establish one of the four tenets of the negligence.
Mm-hmm. Okay. So, how important is it for one to have, for from a doctor's standpoint, because I'm asking this question now for all doctors, how important is it for a doctor to necessarily document what they may think is a diagnosis, their definitive diagnosis, versus differentials? Sometimes we can see, or sometimes we can have situations where physicians may be quite sure that it is a diagnosis of X. Is it important to, once you have not done the full gamut of possible investigations, to also document differentials? How important is that? Does it
It,
bear
it,
any
it is
weight?
it is important, but your differential has to have a basis.
Right.
So you can't just say, for instance, I could just give you an example. Um, Someone comes in suffering with a headache. and then you say they're suffering with a urinary tract infection. I'm not a doctor, so I don't know if headaches and urinary tract infections go together. But what I'm saying is far removed from what the other one would be. That
Right.
might be no point in having that differential. But you should document it, and you should also justify why you're documenting it. Because funny enough, I have a similar case at the moment where someone has said there's a differential, and there is no analysis, there's no tests, no investigations to actually suggest that that differential was a serious consideration.
Right. Okay.
And
Interesting.
added to that, in terms of the medical care, we also would say that in terms of the diagnosis, you need to cross your T's and dot your I's. So whilst you might think it's X, make sure that you're able to justify why you think it's X. We're not saying
Right.
that you cannot be wrong, but what we're saying is you need to know that when you made that diagnosis, you made it with the best information available.
Great. Excellent. So again, following the standard of care if you
Yes,
thought that a diagnosis was excellent. Good.
that's right.
Okay, so we have a question. Well, we have a question from the message board, and then I have another question for you.
Okay.
So we have here a nurse informs a relative that the doctor has instructed her to discontinue treatment, let's say oxygen therapy. The
Right.
patient later goes into arrest and dies. The doctor says he's never instructed the nurse of this. The nurse has documented that she was so instructed. Who would be negligent in this case?
That's a difficult one. Um, Possibly the nurse, in the sense that where is the instruction? When the doctor normally gives instructions for something as serious as that, using my favorite words again, it should be documented. So if there's nothing in the records that suggests that the doctor said that, in this particular instance, it's potentially more likely to be the nurse that would be found to be at fault. I do
Right.
know that sounds like in an artificial setting, because obviously doctors do give instructions to do X, Y, and Z without documenting it. But in terms of looking at it from a legal standpoint, we would want to know where that instruction came from. And obviously, it's going to be she said, he said, and then
Right.
that will ultimately come down to credibility. Which of the two of them's evidence do you prefer?
That is quite interesting. We're learning a lot this evening, both from the patient end and the physician's end.
Yep.
We have another. I have another question. You have an accident that has occurred as a result of a breach of standard of care.
Yes.
Okay. At that time, no immediate injury is noted. However, 2 to 3 years later, and I purposely use 2 to 3 years because that is the 3 year mark is your statute of limitation.
Yep.
There there is now the presence of a deficit as a result of the breach of standard of care that occurred 2 to 3 years prior.
Right. And in
What
terms of
happened?
the limitation, as I said, in terms of the 3 years, it's either from the date of the incident or from the date of knowledge. So in this particular case, the fact that it only came to light close to the 3 year mark would be when the actual limitation period would start to run, not from the date when the actual medical issue occurred. So, in other words, basically, whilst their treatment was done, then no adverse finding had occurred, and then it only subsequently came to light at a much later date. That's when the investigative period for the 3 year limitation period would apply. So it will
And
still be 3 years, but 3 years from the date of knowledge.
and would that physician or healthcare provider still be held culpable given the fact that there was a breach of care, but initially there was no injury that occurred? Because the physician may argue, but we had a breach of care, but there was no injury that occurred. How is it that now you are able to prove causality?
Yeah, and it's essentially, in terms of, there's lots of words that I bandy around. Foreseeability is a critical word when you're doing a case of negligence. It
Right.
has to be reasonably foreseeable that if the person did whatever they did, and then it didn't result in injury at the time, but it subsequently did, there has to kind of be a chain to suggest how we went from that negligence leading to the incident 2 or 3 years later. And that's when
Okay.
the medical experts would come into play again. So
Right.
it happens all the time. You didn't diagnose something at the time which you should have diagnosed. By not diagnosing it, it's far worse when it's finally diagnosed. You will be held liable.
Okay, we have another question. How liable is the doctor if the preferred plan of care is not available, or worse yet, affordable to the patient after offering such to them?
Now, that's an interesting one. I would have to say, obviously, you can only work within the resources that are available to you. So essentially, once the doctor has advised what the treatment should be and explored the options that if you can't afford it, you could do, you could go see if it's available privately, sorry, not privately, at the QEH or wherever it would be, then that would be an option where I think you would have exhausted your duty or you would have fulfilled your duty. Because obviously, whilst a doctor has quite a wide standard of care, it's not limitless. So you've advised them of what needs to be done, you've advised them where it should be done or where it could be done, then I don't know what more, if the standard of care would come into play at that point. I don't think so, but that's what I might have to answer for you at another time.
Okay. I wanted to sort of take a step away from physician patient interaction and now move to another space, which is the space of pharmacy
Yep.
patient interaction.
Uh-huh.
And medication is carried in the pharmacy. However, as you know, quite often we see lots of medications are recalled in Canada and in Barbados and in the United States of America. However, there is a concern that that particular medication may be on the shelves here locally. Does that pharmacist have a duty of care not to continue to issue that medication even if the doctor has prescribed it?
Yes, he has a duty. So basically, each medical personnel has a duty to keep up with um, the modern state of knowledge. That is a duty, and failure to do that could be viewed to be breach of the standard of care. So, whilst the doctor has prescribed it, if the pharmacist knows that he shouldn't prescribe it because it's been recalled or whatever, he has a duty then to interact with that doctor and determine an alternative.
Okay. Um, Going even further away from the normal practicing physician space, I'm going to take it all the way to the side of death. Patient has received breaching a standard of care. It has resulted in death. Can that patient's spouse or next of kin bring legal action against the physician?
Yes, they can. Yes, they can. So basically, they would do the claim, but they would just do it based as the administrators or the executors of the deceased person's estate. But once there was
And
a claim, and then they would be claiming for loss of that person's life and claiming for all the factors or the things that that person did for them that they're not able to do now, result of the negligence which killed them.
and is it always necessary or highly encouraged that an autopsy is performed?
Yes, not always. It depends on the facts of the claim. I
Right.
usually err on the side of caution and say if there's any likelihood that some places, and the doctor will know this at the outset, in terms of told the persons that the patient was likely to live and
Right.
then unexpectedly they died. In situations like that, I would say it would probably better to get an autopsy than not to get one, because you're just again crossing your T's and dotting your I's. But randomly, for every case, cases where people just died pretty much it was expected, then I would say no. I wouldn't necessarily advise getting an autopsy.
Okay. Do you think that the absence of an autopsy can sometimes make a claim difficult?
It sometimes can, or it sometimes can make it easier by having one. Because if
Right.
you're alleging, for instance, that wrong medication was given, and as an example, and then you can do the autopsy, and the autopsy clearly shows that it's the medication that killed that person, it would
Right.
definitely help you in terms of proving liability. Because even, once you've proved the standard of care was breached, the actual loss part is obvious. Whereas if you didn't have that autopsy, it might be slightly more difficult to prove that it was the medicine that actually killed the person. Just as a one example.
Okay. Can pre-hospital specialists, so for instance, we're now going in the space of paramedics, EMTs, can they be held legally responsible?
I would say yes. I haven't had a case that I have actually seen the EMTs or the paramedical ones but they would be viewed as medical personnel, and there definitely still is a standard of care that they have to meet. It wouldn't
Right.
be the standard of care of a doctor. It would be a standard of care of other paramedics in the same situation.
Okay. All right.
But
And
there's no
what this,
reason why they could not be sued if they didn't do what they're supposed to do, because they still have a duty of care and a
and
standard that they're supposed to adhere to.
and that standard of care is always whether it is for a pharmacist, physician, EMT or paramedic or any physiotherapist or anything in the paramedical space, that is based upon
They would all be viewed as
right.
medical personnel, and any of them could be sued if they did not do what they were supposed to do or come up to the standard of care that was expected of that person in that field.
And is that standard based upon your jurisdiction or is that an international standard of care?
Generally speaking, it's based upon the jurisdiction, and it's also based upon the time that this happened. So in other words, if you're complaining about something that happened in 2012 and medical knowledge has moved on in 2021, you can't judge it by the standard of the medical knowledge in 2021. You have to look back to 2012 when the incident occurred.
Right.
In terms of jurisdiction, it's like for like. So there's a certain minimum standard of care throughout, but
Okay.
you can't compare, just for example, the QEH or the hospital in Barbados with maybe 15, 20, 30 hospitals in America in the same state, in the same size state,
Right.
because obviously the facilities will be better, the resources might be more. So,
Right.
like in a case in Barbados of negligence, we try to find a doctor to give advice or give expert opinion within the region, because
Okay.
we're working on the basis that it's probably similar
In
situation.
terms of resources and stuff of the sort.
That's correct. You can go outside, but in going outside and finding an expert outside of the jurisdiction, you have to take on board what would happen in the jurisdiction in the country where the actual incident occurred.
Okay. I have a question here. What effect would an intervening act have on negligent liability?
Yes, depending on
Especially
what it
if the
was.
intervening especially if the intervening act or omission is on the part of the patient.
Well, there's two issues. There's one where, depending on what the patient did, there would be maybe a contribution known as contributory negligence, and that is that you share some liability for whatever occurred. So, just as an
Right.
example, a very straightforward example, doctor tells you not to take this medication without food, and
Okay.
you take it without food. You take it without food and you have an adverse reaction. Well, you were advised that if you did that, you'd have an adverse reaction. Whilst the doctor might be liable for prescribing such a medication, you would definitely have some liability to take for not following the instructions that were given by that doctor. And in terms of the intervening act, I referred earlier to causation. And you also have to basically prove but for the doctor's action, whatever happened to you would not have occurred. So if there's an intervening act, it's much more difficult for you to prove that. So let's see, I'm just trying to think of an example. Okay, this is a very, it's just an easy to understand example. Doctors performing in a operation, oxygen's needed. Somebody removes the plug for the oxygen, and so therefore, as a result of that, say the doctor's done something that was negligent, but in doing so, somebody removes the plug that's needed for oxygen and the person dies. Removal of the plug would have been that intervening act. But the question that you would have to ask is, but for the removal of that plug, would the person have died? And the answer would be yes or no, depending on the facts of the particular case. So intervening acts do play a part, and they are relevant, because definitely you have to, but for whatever the negligent act was, would the act have occurred? And depending on your answer will depend whether or not you're likely to succeed in a negligence action.
Okay. We have another question. What about herbal medicine and alternative medicine practitioners? If they cause harm, are they liable to a charge of negligence? And this is something that I think we see a lot, not just here locally, but on the international stage. Are they held to the same standard of care as a healthcare provider?
That's an interesting question that I don't have the immediate answer to. Never thought about it. But just thinking about it, when you do a clinical negligence, it's medical personnel. So would that healthcare provider be classed as medical personnel? Potentially, yes. And therefore, they would have to be held to a certain standard. And so therefore, I think there would be a claim to answer if they prescribed something, someone had an adverse reaction, and it was known that they could have had an adverse reaction, and they didn't advise that person. Yes, I think the person would have a potential claim against them.
Okay, I have another question for you, because it is all in the definition of words. What if the person, and I'll take this last question a step further, that alternative medicine practitioner did not prescribe medication, but they recommended medication? Would they be still considered liable if an adverse outcome occurred?
I definitely think there would be a case to answer, because you went to that person relying upon, they held themselves out to be an expert, so to speak, in the field. And you went to that person on the basis that they would provide you with the evidence, the information that you needed. They advised you to get X or Y, you did so and had it. I think that they would still be liable. Especially, but then the issue would be, you see, in terms of just simply having an allergic reaction, was it foreseeable? Is there anything they could have done to avoid you having the allergic reaction? They're all the questions. It's never a straightforward yes or no. There are so many permutations, but general answer, they definitely would be a case to answer.
Okay. At this point in time, Ms. Moore, we have gone through a myriad of scenarios, because I actually am quite happy that you took the opportunity to come out to us, because generally speaking, there's nothing like case law in order to really bring about and emphasize the points that you should learn from a particular area, if I'm correct. That's at least how I learned it, certainly from giving evidence and testimony, and then in the field of medicine. But I wanted to ask, are there any take-home points that you can probably split it into two, that you can first and foremost give to the patient in terms of how they should go about establishing that there is even negligence, if they think that they have been wronged, and certainly to the physicians or any healthcare providers in ensuring that they always practice to the standard of care?
Right. So in relation to the patient, what I would say is, if they feel that they have a potential complaint, Their first port of call can be before they come to a lawyer. They can raise it with the physician or the hospital, because sometimes it might simply be a misunderstanding, because a patient often has the view that once they've been to a doctor, that doctor is supposed to treat them and essentially they're supposed to get better. And we know that it doesn't always happen like that. With the best will in the world, everyone doesn't always get better. But then if they find that the answers that they have been given are not satisfactory, then they should actually seek legal advice. They might or might not be told they have a claim, but at least they'll have a clearer idea of what it is they need to do and what they need to establish for a negligence action. Because negligence actions are quite hard to prove unless it's really, really obvious. And
Right.
for the doctors, what I would say to them is, with their interaction with the patient, to try as far as possible to always ensure that they are giving the best care that they can, and document what they say and do to the patient clearly, because then it will stand up to scrutiny should a complaint be made against them.
Okay. While you were giving your closing comments, a question actually came to mind. Does a doctor have a duty of care if he or she is unable to provide the standard of care based upon limited resources or based upon the financial restraints of a patient, to either refer or discharge that patient's care to another doctor or
I
even
would say
another
the answer,
institution?
I would say the answer would be yes, because once that patient is on your books and you are not providing them with what is deemed a reasonable standard of care, you are subject to a negligence action.
Okay, great. I want to say thank you so much, Ms. Moore, for coming this evening and really opening up our eyes to really what is the standard of care and how both patients and healthcare providers alike can ensure that they benefit from the standard of care that is given and the avoidance of malpractice. I want to say thank you for taking, because I know you're very, very busy. So I want to say thank you very, very much for taking the time out to come and have this discussion with us. And I also want to say thanks to our listeners who've participated quite nicely within our message board. I want to say, if you have any further questions, please feel free to drop the questions on, whether it's on our Instagram or our Facebook page. And certainly, once again, continue to follow us on Podbean and Anchor, and join us next week as we continue our scope outside of medicine, discussing insurance and the importance of health insurance. Have a good evening, everyone.
Thank you.
Go ahead,
I
Marilyn.
would just like to say thank you for giving me the opportunity to speak on this subject, which is very dear to me.
Thank you. Thanks, everybody. Have a wonderful evening. Bye-bye.
Goodbye.